Hi, Gary DeWaal here, and this is Bridging the Week for July 7th to 11th, and today is July 14, 2014. Good morning. Halloween seems to have come early as old ghosts haunted the financial services industry last week, with different forums again addressing market structure and high-frequency trading, and one court issuing a ruling in a malpractice lawsuit arising from the demise of MF Global in October 2011. Let's start trick-and-treating with today's top articles, beginning with news about MF Global. Last week, a U.S. court in New York City rejected an effort by PricewaterhouseCoopers to have a complaint against it by the MF Global Holdings plan administrator, that's the successor to the bankruptcy trustee, dismissed. The plan administrator previously had filed an action against PwC, the firm's outside auditor and accountant, claiming that PwC's, quote, extraordinary and egregious professional malpractice and negligence, end of quote, had caused MF Global losses in excess of $1 billion US. Specifically, the plan administrator argued that MF Global failed in October 2011 because of financial pressures that arose from its proprietary investments in European sovereign debt through repurchase to maturity transactions and its tax treatment of certain assets, so-called deferred tax assets. The plan administrator claims that MF Global relied on PwC's advice on how to account for the RTM transactions as well as the deferred tax assets. Ultimately, MF Global had to act contrary to the advice, ultimately realizing substantial losses. It is these losses, claims the plan administrator, that led MF Global to bankruptcy. PwC argued, on the other hand, that as a successor to MF Global, the plan administrator could not prevail in this lawsuit because the company acted through authorized employees, participated in the same conduct that accused PwC of engaging in. The court concluded that MF Global, at least relying on the face of the plan administrator's lawsuit, did not play a role in formulating the allegedly erroneous advice given to the firm by PwC. Other aspects of PwC's motion to dismiss await to be briefed and determined by the court before a trial is scheduled on the substantive claim. Wow, this thing is going on for a long, long time. Last week, the U.S. Senate Committee on Banking, Housing, and Urban Affairs held a hearing in Washington, D.C. to examine the role of regulation in shaping equity market structure and electronic trading. During the same week, a senior policy advisor at the Federal Reserve Bank of Chicago published his recommendations to help, quote, restore the perception of fairness and balance to market participants, end of quote, while the UK Financial Conduct Authority announced its study of, quote, markets and market infrastructure where competition may not be working effectively, end of quote. During the Senate Banking Committee hearing, a wide range of industry leaders presented their views. Tim Johnson, chairman of the Senate Banking Committee, began the hearing by acknowledging that benefits to investors that have come about because of high-frequency trading and the evolution of market structure, including lower cost and more efficient trading. Overall, there were not many new ideas expressed during this hearing. However, in his testimony, Ken Griffin, CEO of Citadel LLC, proposed that the limited liability that historically has been accorded exchanges as self-regulatory organizations should be removed. This is because of the quote-unquote irreconcilable conflict of interest that now exists between exchanges who have a fiduciary duty to maximize their shareholder profits and their broker-dealer members with whom they compete. In his study for the Federal Reserve Bank of Chicago, John McPartland, senior policy advisor in the Financial Markets Group, principally addressed issues around high-frequency trading, while acknowledging the views of many industry observers that high-frequency trading offers many benefits to financial markets, including enhancing liquidity, improving bid-ask spreads, and decreasing price volatility. He nonetheless offered 9 recommendations to address concerns by some commentators that, quote, some HFT practitioners utilize trading techniques that are detrimental, quote-unquote, to financial markets. Mr. McPartland's most interesting recommendations is that trading venues should not provide trade information to market participants from the location of their March engines, but from another location outside their data center. This is to avoid having market participants located in trading venues co-location facilities from receiving trade information sooner than other market participants because of the law of physics surrounding latency. In Mr. McPartland's views, only participants who had actual trade should receive information regarding the trade on an advantageous basis. All other market participants, no matter where located, should receive information equally. Finally, the UK FCA is seeking comment about its competition concerns related to market structure and other aspects of wholesale financial markets. Specifically, the authority believes there may be competition issues related to how market participants use trade data, access markets in the first instance, package trading and clearing services, and use co-location services. Among other areas, the Financial Conduct Authority hopes to receive comments on the benefits and disadvantages of having vertically organized execution and clearing organizations. The FCA invites comments through October 9th. The European Securities and Markets Authority began on July 11th the process for the mandatory clearing of certain interest rate and credit default swaps by certain European Union counterparties through clearinghouses that have been authorized if European or recognized if non-European under the European Market Infrastructure Regulation Framework. ESMA proposes that 4 classes of interest rate swaps and untrans-indexed credit default swaps be subject to mandatory clearing. The International Swaps and Derivatives Association and the Securities Industry and Financial Markets Association requested last week that the Commodity Futures Trading Commission not proceed at this time with endeavoring to implement its proposed new rules regarding speculative position limits issued during November 2013. This request was made in a letter to the CFTC in response to the agency's reopening of the comment period related to the proposed new rules on June 27th for an additional 30 days. And finally, ESMA also last week issued a revised question and answers relating to clearinghouses, trade repositories, and OTC derivatives under EMIR. Among other matters, the Q&As clarify ESMA's view that non-EU clearing members of EU clearinghouses providing services to all clients, both EU and non-EU, are subject to EMIR's segregation requirements. These requirements mandate that clearing members must offer their clients a choice between omnibus client segregation and individual client segregation. However, where a third country's insolvency regime makes such offering impractical, such as in the US, the clearing member should offer its clients alternative possibilities to ensure they may receive the choice of protections. Such possibilities include, quote-unquote, clearing solutions provided by an affiliate or other clearing member of the CCP, or clearinghouse. Well, that's it for this week's Bridging the Week. As always, there is more information in each article, and more articles on the article version of Bridging the Week on the Gary DeWaal and Associates website. Check it out. Until next week, this is Gary DeWaal. Have a great week, and ciao!